We have just received major new developments in one of the biggest legal battles in NASCAR history. With the trial now just 2 months away, tension is building fast. Major figures like Joe Gibbs, Hendrick, and Roger Penske are publicly urging both sides to settle their differences before the case reaches court. So, what exactly does this lawsuit mean, and what could it change for the entire sport of stock car racing? Let's find out in today's deep dive. The charter system was designed to stabilize team finances and give owners guaranteed entry into races. Before this, smaller teams struggled every week just to qualify for races, often spending huge sums of money without any guarantee of participating. The introduction of the 36 charters in 2016 changed that by giving established teams a form of franchise status, similar to major sports leagues like the NFL or NBA. Each charter came with value because it guaranteed a spot in every race, revenue sharing from TV deals, and the ability to sell or transfer the charter. Over time, some charters became worth over $10 million each. The system gave teams long-term security, but it also made NASCAR more centralized and gave the organization massive control over team participation. This concentration of control is what led to the antitrust lawsuit. In December of 2024, 23XI Racing, co-owned by NBA legend Michael Jordan and NASCAR driver Denny Hamlin, joined forces with Front Row Motorsports to file a legal case accusing NASCAR of anti-competitive behavior. The teams argued that NASCAR's control over race participation and sanctioning prevented fair competition and violated the Sherman Act, a federal law meant to prevent monopolies and protect fair business practices. The lawsuit claimed that NASCAR's agreements, including its charter contracts, were structured to block teams from exploring independent opportunities or even negotiating better financial terms. In early October 2025, NASCAR responded aggressively by filing a motion for summary judgment. This motion requested Judge Kenneth Bell to dismiss the case before it even reached trial. NASCAR's legal argument had several layers, but the core of it focused on timing and contractual agreements. They stated that the statute of limitations for Sherman Act claims is 4 years, and since most of the conduct being challenged occurred between 2016 and 2019, the teams had waited too long to file the case. They reminded the court that when teams signed the original charter agreement in 2016, they had to agree to a release clause, which meant that by signing the contract, they waived the right to sue NASCAR for actions related to the agreement. NASCAR's lawyers also argued that the teams failed to clearly separate legal and illegal behavior in their claims. They said the plaintiffs were too vague about what exactly they wanted in damages, making it impossible for a jury to evaluate the case without speculation. Another point NASCAR raised was that the plaintiffs admitted they were not trying to create a rival racing series, meaning they were not truly being excluded from competition. In NASCAR's view, this proved that there was no real harm caused by its agreements. In a public statement, NASCAR said that the lawsuit was not about antitrust issues at all, but merely an attempt by a few individuals to renegotiate contracts they had already signed. The statement went further by calling out Curtis Polk, Michael Jordan's longtime business partner and a 23XI Racing executive, accusing him of trying to use collusion among teams to pressure NASCAR into better deals. NASCAR's statement ended sharply, saying that neither greed nor bruised egos justified trying to destroy an institution that thousands of people had spent decades building. The reaction from other team owners was both swift and significant. Many of NASCAR's top owners filed official declarations supporting the charter system and urging the court and both parties to find a peaceful resolution. Roger Penske defended both NASCAR and the charter system in his declaration. Penske explained that the introduction of the next-gen car in 2022 had actually reduced his team's expenses by lowering the number of cars needed and decreasing the cost of parts. He also said that the standardization of parts made competition more equal and manageable. Penske mentioned that he implemented a similar charter model in IndyCar to provide long-term stability and to protect team investments. Brad Keselowski added that although teams did not get everything they wanted in the 2025 charter negotiations, the final agreement was a fair compromise that benefited everyone in the long term. He also shared an interesting personal example, mentioning that he had competed in the 2023 SRX Series, a rival racing league, while still being a Cup Series driver and co-owner. NASCAR did not stop him from doing that, which he used to demonstrate that NASCAR was not acting as a monopoly, blocking competition. Other owners, however, expressed concern about the legal uncertainty the lawsuit was creating. Gordon Smith of Hayek Motorsports said he had serious concerns about how the ongoing litigation might harm the sport's future. Rick Hendrick, the winningest owner in NASCAR history, warned that undoing the agreements that all teams in NASCAR had carefully negotiated would cause immeasurable damage. He said the dispute could affect thousands of people whose livelihoods depend on the sport, from mechanics and engineers to sponsors and local racetrack owners. Joe Gibbs, who finds himself in a complicated position, also submitted a declaration. His team, Joe Gibbs Racing, has a close alliance with 23XI Racing, one of the plaintiffs in the case. This has put him in a difficult situation as one of his partner teams is suing the same organization that has governed his own racing operations for decades. Still, Gibbs joined the other team owners in calling for a peaceful resolution, saying that the long-term health of the sport should come before any short-term business dispute. Judge Kenneth Bell has remained cautious throughout the proceedings. He has previously shown reluctance to make quick rulings and has repeatedly encouraged both sides to negotiate and settle outside of court. In an earlier injunction matter, he delayed his decision until NASCAR made small rule adjustments that allowed an easier resolution. His pattern suggests that he prefers compromise over confrontation. Most observers believe Judge Bell will allow the case to go to trial in December rather than dismissing it outright, but he'll continue to urge both parties to settle beforehand. The two teams have accused NASCAR of operating as a monopoly. They argue that NASCAR controls too much: the tracks, the series, and the rules that dictate who can race and where. If they win, it's possible that NASCAR could be forced to sell off some of its racetracks or even part of its series operations. They're also asking for fewer restrictions on where teams can race and how the next-gen car can be used outside NASCAR-owned events. One of their biggest demands is for permanent charters, which would allow teams to have guaranteed spots in races and more financial security. They also say they want a larger seat at the decision-making table, though that part of their demand remains vague. Nobody knows exactly what that means or how it would work in practice. Interestingly, NASCAR has hinted that if the legal challenge goes too far, it might dissolve the charter system entirely. That statement has made many other owners, like Rick Hendrick, Roger Penske, and Richard Childress, very uneasy. They have all submitted formal declarations supporting the current system, not because they think it's perfect, but because it at least gives them predictability for the next 6 or 7 years. Without the charter system, every team would have to compete for entry in races purely on performance, and the value of existing charters could fall to zero overnight. That potential risk has united many team owners who normally compete fiercely against each other. As always, don't forget to give this video a like, hit that subscribe button, and also ring that notification bell while you're down there.